Rob, good to see you.
Afternoon.
So I've been thinking about how parties might weaponise undertakings to the court in 1954 Act proceedings and thought it would be great to get your views on it. So to set the scene, let you know what I'm on about. This is all about ways that a landlord can satisfy the requirement of intention, typically in ground F cases, the redevelopment opposition ground, but also in ground G cases where the landlord says that it intends to occupy the premises. So to oppose the grant of a new lease, the landlord has to demonstrate that it intends to carry out qualifying works. And there are lots of different requirements within that, but two key requirements are first, subjective intention, which basically means that the intention must be, on the one hand, genuine and made in good faith, and on the other hand, firm and settled, in cases say, and not contemplative or likely to be changed. And then, of course, as well, secondly, there's Francis intention, which basically means the landlord has to want to do the works for their own sake, for their own benefit. And the way you test that is by asking hypothetically whether the landlord would carry out exactly the same works if the tenant vacated voluntarily.
Yeah, so this is something we've had a lot of experience in recently, actually. So focusing on the subjective intention part, there are in essence two ways the landlord's stated subjective intention is insufficient or is often challenged. The first being when the landlord may be looking to obtain negotiation leverage and might in fact have no intention of carrying out the works. And the second, which is common, is the landlord may genuinely think the works are a good idea, but might not have settled on a firm intention, decision yet, often because it's still weighing up its options and deciding what it wants to really do. This will always be a question of fact, and often the tenant will want to go on the attack on either of those bases. So, one way the tenant can try and put this issue of intention to bed is by giving an undertaking to the court to do the works. So it's saying, I'll do the works, and if I don't, I'll be guilty of contempt of court and you can sequester my assets. And this can be really effective. We often tend to find, however, that it's not often used, as ultimately what landlord wants to give that undertaking. What if the landlord's intentions do change? And also, what if the landlord's funding position changes? We tend to find landlords leave that for the last minute, often just ahead of a trial, before suggesting any undertakings of that nature. And that's really the basic backdrop.
Yeah, okay. So the first thing I was thinking about is what should a tenant do before trial if the landlord hasn't itself offered an undertaking? And there's a bit of a game of double or quits that the tenant might play. So the tenant might do absolutely nothing, hoping that the landlord will never offer an undertaking, and then it can just attack subjective intention in the usual way and look at the plans, look at what's happened, etc. Or the tenant can play this game of double or quits and ask for an undertaking at an early stage. So doing so exploits the point you just made, Rob. No landlord wants to give an undertaking before it's absolutely necessary to do so. So the landlord might say no. And if the landlord says no, that really helps the tenant out on subjective intention. You know, the very first submission on this is, why is the landlord telling the court that it intends to do the works, but it's not prepared to commit to them by giving an undertaking? It's not putting its money where its mouth is, if you like. But that's the double bit, but the quits bit. What if the landlord says yes? Well, the landlord's case there on subjective intention is going to be stronger. But I suppose, at least in those circumstances, the tenant will know where it is.
Yeah, and that also leads on to what should a tenant do if an undertaking is offered. Firstly, they often challenge the terms of the undertaking itself, and they really look to pile on the pressure by insisting the undertaking is cast iron and properly enforceable. And this way, they try and box in a landlord. Tenants in this scenario, we tend to find, seem to ensure that the undertaking properly and precisely describes the works, specifies when the works are due to start, and provides for policing the undertaking by the tenant. So this is often allowing for a right to apply to court and a right for the tenant to inspect the premises. All the undertakings can provide for a right of damages in the event that the works don't happen.
Yeah, so there's a bit of game playing or a bit of weaponizing that can happen here, because the tenant can really insist on this stringent undertaking. And you can see some of those points in the Francis litigation before Mr. Justice J, that some of these points on the terms of the undertaking come out. But there's an extra little point here as well, an extra little thing the tenant can do. And that arises because undertakings are solemn promises given to the court, and they're not discharged or varied lightly. A landlord would normally need to show some significant change of circumstance, and that circumstance is one which couldn't reasonably be regarded as contemplated when giving the undertaking. So that can be a really difficult test to meet. But the court normally won't interfere with the terms of the undertaking when it's actually given. So the tenant can exploit this. The tenant can agree to a term that the undertaking may be released with the tenant's consent. And that can be really important because the tenant then holds the key to let the landlord off. Otherwise, an undertaking might be a bit like a tenant cutting its nose off to spite its face, because the landlord will get stuck with this undertaking it's given to court. But what good is that to the tenant if vacant possession is ordered, if a new lease isn't ordered and the original lease is terminated? If this sort of clause is included, the tenant at least might get a payout by agreeing a fee for the undertaking's release in the event that the landlord's plans change.
Yeah, and secondly, on top of that, I mean, when the tenants are met with an undertaking, it's still open for the tenant to consider whether that undertaking does actually mean that the question of subjective intention is truly settled. It's open for the courts to disbelieve the landlord in the face of an undertaking, so it's not absolute.
Yeah, all's not lost. All's not lost. Well, look, lastly, if you're a tenant and you are faced with an undertaking given just before trial or even at trial, you can always think cost argument. You might say, well, look, I've now got a losing case because I was putting all my eggs in the subjective intention basket, but I'm only losing this case now because the landlord has decided to give an undertaking, which it could have given all along and saved us all this trouble. And those sorts of cost arguments are going to be even better if the tenant has played the game of double or quits and asked for an undertaking at an early stage, and the landlord said no, only belatedly to offer one at trial. Last little point. I should say there's a nice point about whether an undertaking properly given in the correct form can be used to satisfy the Francis intention requirement as well. There's a little bit in the Supreme Court decision about this, but I think it's for another day. But if you have a case on that, or if anyone watching this has a case on that, I've got some thoughts. So get in touch and it would be good to discuss it. But Rob, thanks so much for the really interesting discussion.
Yeah, thank you.